Our second case scheduled for oral argument this afternoon is Renee Creek as person representative of the estate of George Creek versus C.L. Golden LLC. Counsel, ready to proceed?
Thank you.
You may approach. Again, counsel, we've allocated 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
I would, Your Honor, and I'd like to reserve 5 minutes, please.
So noted, Madam Clerk. You may continue, counsel.
Thank you. We're here today because the trial court on a motion to dismiss found that our third amended complaint was a COVID claim as defined by Florida statutes, and that the claim was barred by the statute of limitations that was set forth in the Florida statute regarding COVID claims, despite the fact that there was not a single allegation of COVID-related negligence or COVID-related damages in any of the underlying complaints. This is reversible error for a number of reasons. First and foremost, and I think the easiest and most obvious answer, is because the trial court clearly and blatantly violated the Four Corners rule. This was at a motion to dismiss hearing.
Could the trial court have converted the motion to dismiss to a motion for summary judgment with the filing of the exhibits?
I don't believe, under the way our rules of civil procedure are set up for summary judgment hearings, the court could have unilaterally done such a thing. I think certainly, also the court didn't. It ruled as a motion to dismiss, but I think the rules of civil procedure would have provided us more opportunity to develop the record.
So, counsel, on the Four Corners rule, the complaint did not simply say that all conditions precedent have been satisfied. It went further, and it said that the pre-suit investigation was and is supported by the corroborating affidavit with the notices of intent. So why did that language not, at a minimum, incorporate the affidavit and supply a basis for the trial court to review it?
Well, I think as a primary basis, because it didn't expressly incorporate the affidavit or any of the allegations of the affidavit. So there's no language incorporating it. It simply references it. And then that's where we get to this sort of, rather than an incorporated exhibit, sort of the referenced exhibit. And I don't want to call it a rule because I don't think it is a rule. But there is very, very limited situations where appellate courts have allowed sort of this kind of reference rule. And in all of those situations, what we're really talking about is kind of the court looking past what the actual allegations are and finding, hey, this is really something that the complaint is brought on. It's even if it's not expressly incorporated, say, but a contract for a breach of contract, you're bringing it on the breach of contract, whether you incorporated the contract or not. I think the specific case dealt with a breach of a settlement agreement. Okay, whether you incorporated the settlement agreement or not, you're bringing it on the settlement agreement. So by referencing the settlement agreement, because you probably should have actually, if you were pleading your complaint correctly, incorporated it, we're going to allow that sort of reference. But that's extremely limited, and it's obviously an extremely dangerous and slippery slope.
Right, and so what's unique, I think, in these med-mal cases is that the pre-suit investigation has a purpose to, I guess, weed out frivolous claims, make sure there are claims that are meritorious. And so, given that unique nature of what this affidavit is for, does that not in some way form the basis of the complaint, like an insurance document or a settlement agreement would form the basis of a complaint?
So compliance with the pre-suit procedure form is a prerequisite, certainly. I don't think it forms the basis of the complaint. Now, there's an entirely separate procedure where they could have challenged compliance with the pre-suit procedures. And in that case, in that instance, there have been instances where courts have considered the pre-suit affidavit. One of the next things I was going to go on with is, besides the fact that the court has grossly expanded the referenced, again, I don't want to call it a rule, but the limited application of allowing those things to be considered on a motion to dismiss. The thing it considered was a pre-suit affidavit, which statutorily and by case law can't be considered for any reason once the case goes to the trial court. So again, that's kind of a two-pronged discussion to answer your argument, but there is a way to challenge compliance with pre-suit procedures. And had there been any issue with our compliance with the pre-suit procedures, they certainly could have challenged that. They didn't. That's not what this was a challenge of.
But was there really any question about compliance with the pre-suit procedures? I mean, that's not really the question here. The question
Correct.
was this a COVID-related claim? And did this complaint, obviously avoid pleading that to avoid the statute of limitations would be another way to look at it, right?
In theory, that is one way that it could be looked at. And if that was the case, like any situation where someone pleads an issue and factually, the factuals will not bear out what the pleadings state, on a summary judgment, the court can consider the factuals. At the motion to dismiss stage, the court needs to consider the four corners. This was not a summary judgment hearing. I wasn't provided an opportunity to put forth any of my evidence as to why it wasn't a COVID-related claim. I did a pre-suit affidavit where I shared it in the spirit of pre-suit cooperation, where you're supposed to try to share everything because it can't be used against you later. And yes, part of the investigation found that the doctor was negligent multiple times. And this goes to my next argument.
Well, and before you move on, though,
Yeah.
and picking up where Judge Ray left off on kind of this gatekeeping role that the pre-suit process has, particularly as it relates to COVID-related claims, if we accept your argument, then that means that the plaintiff can plead around the COVID-related claims, and then the defendant has to go through discovery in order, and then you have to get to summary judgment before they can avoid suit. And isn't that at odds with the whole pre-suit kind of scheme that we have here in Florida?
Well, again, had we been bringing a COVID-related claim, it could have been borne out in the pre-suit process. We elected the ultimate decedent ended up making a full recovery from COVID. Our pre-suit expert did an investigation and found, prior to him getting COVID, there was medical negligence resulting in failure to inspect and provide medical treatment to his lower limbs due to lack of circulation. During the course of treatment, subsequently, this doctor was negligent again in allowing this person to get COVID. He recovers from COVID and then ultimately continues to not get proper treatment for his leg conditions, loses his leg, and ultimately passes away. What the defense has tried to do is basically use the fact that the doctor was negligent a second time and the fact that it was related to COVID as a get-out-of-jail-free card for the prior negligence. That's the only case we brought. We get to select our remedies. Just because I could sue somebody for a COVID claim and a second claim doesn't mean I have to bring the COVID claim. And again, we didn't bring the COVID claim because he made a recovery from the COVID.
Was COVID mentioned anywhere in the complaint?
Nowhere. And again, this is at a motion to dismiss hearing. And furthermore, using a pre-suit affidavit, despite the clear statutory strictures that they are not admissible in any civil action for any purpose by the opposing party. That's actually in two separate statutes. It's as broad a prohibition as I'm aware of in the law. Again, we talked about the incorporate by reference expansion. But I think, one of the key things here is, I'm up here discussing and arguing factual details about a affidavit that wasn't admitted into evidence, that can't be used in any civil proceeding, that was at a motion to dismiss hearing, that I wasn't provided any opportunity to provide evidence against. But if we want to go there, because that's the position that the trial court's errors has put me in, a COVID-related claim is defined under 768-381, 1 sub D, that discusses diagnosis or treatment or failure to diagnose or treat COVID, provision of a novel or experimental COVID-19 treatment, transmission of COVID-19, delay or cancellation of surgery/procedure based on COVID-19, lack of resources directly caused by the COVID pandemic, or the treatment of a COVID-19 patient whose injuries were directly related to COVID-19 exacerbations of pre-existing conditions. None of the allegations in the complaint relate to that. The cause of action for medical negligence, which pre-existed this individual ever getting COVID-19, have nothing to do with COVID-19. And again, we are not faulting Dr. Lurie or anybody in this case for any of their handling of the COVID-19 claim or his COVID-19. There is no allegation that they did anything wrong in our complaint about COVID-19. Our case has nothing to do with COVID-19. Yes, our pre-suit expert found that there was some negligence related to COVID-19. That's it. That's
So
all
what
that
about the
happened.
Bove case, in which I guess the trial court did rely on something, information in the notice of intent, is that correct?
Yes.
And why was it appropriate there for the trial court to look at a document that wasn't attached to the complaint, but it's not okay here?
Well, in circumstances where the issue is compliance with pre-suit procedures, that's when you need to kind of open up the box and look at what occurred during the pre-suit, separate and apart from the underlying merits and proceedings of the case. And those are the only circumstances because, again, as we mentioned, the statutes are very clear. They can't be used against you in the civil proceeding at all. So if you're trying to figure out if there was pre-suit compliance, which, again, there's no question there was here, so that's not what we're looking at, it is patently improper to consider that affidavit, even if it was actually incorporated. And again, even if it's incorporated, even if you're looking at it, the pre-suit affidavit set forth the negligence claim that I brought, and also a separate act of negligence related to COVID. Just because again, this statute was not meant to be a get-out-of-jail-free card for doctors who commit medical negligence and then have a patient get COVID-19 and then they're negligent again. It would protect them regarding the damages related to the negligence of the COVID-19, which it successfully did that. We didn't sue them for that. And so the statute has served its purpose.
So I think I better understand your alternative argument is ensure that even if we accept the affidavit's incorporated and everything in it, nothing in the complaint or the affidavit would defeat your medical negligence claims under a theory that they are in fact COVID-19 related claims, that there's just no allegation to support a COVID-19 claim within the meaning of the COVID statute.
Correct. Within my complaint, as I put, and again, even accepting the affidavit is true, that would set forth two cases, potential COVID-19 case and our case. And we elected in our choice of
But your
remedy to bring our
position
case.
is, under the Four Corners rule, we don't even get there?
Yes, we shouldn't be there. Again, if this is something, I mean, hopefully they don't, I mean, this has been years and years and years for my client. And we've gone nowhere in this case, unfortunately, because of this being decided over and over again on a motion to dismiss. But they want to raise this again at summary judgment. We'll provide our full factual case. They'll provide their full factual case. If there's a question of fact and they still believe that, it's valid, they can have a jury decide a question of fact. But ultimately, you can't, it's like almost a reverse, like gotcha card summary judgment hearing, in that they get to select one piece of evidence implied by reference that just happens to mention COVID, although it doesn't, defeat my underlying claim, and say, all right, well, your guy got COVID, you're out of luck. And it's just patently improper. And I will reserve the rest of my time. Thank you.
Thank you, Counsel. You may continue, Counsel.
May it please the court. Jason Nazarone, I'm here on behalf of Dr. Lurie. Joshua Salmon is here on behalf of CL Gold, and I'll be arguing for 15 minutes, and then I'll have Mr. Salmon come up and speak on behalf of his client. Your Honors, this is a case in reality about standing, because standing is the ability of a party to invoke the power of the court. And I believe, as Judge Ray noted, in order to do that in a medical malpractice case, a party is required to go through the pre-suit process and follow that process. Because without doing that, they are not entitled to bring a medical malpractice case. It's not like any other case where you can be in a car accident and you have a right to court. You have something happen at a store, you slip and fall, you have a right to file a lawsuit. You don't have that in the medical malpractice context. You have to comply with pre-suit. And one of the things that you have to do to comply with pre-suit is file the notice of intent within the statute of limitations. That is something that must be done. And if it is not done, there is no compliance with pre-suit, and therefore you cannot bring the case. That's what this case is about. Because when you have a claim and you have that notice of intent and you have that affidavit, that is, per the legislature, them saying, Mr. Plaintiff, Mrs. Plaintiff, you have to get an expert. You have to go and you have to have an expert review this case, and then you have to tell the defendant what they did wrong. According to the Bove case, that is a pleading. That is a factual position that you are taking in your case because the defendant relies upon it. The defendant relies upon that because from that information, they are required to then conduct their own investigation. They are required to go and get their own expert and say, okay, is this a case that we may want to settle? Is this a case that we want to litigate? Or is this a case that we may want to invoke the Medical Malpractice Act's arbitration clause? So when a party gets a document, like in this case, that clearly says this is a COVID matter, and it's not just in the affidavit, Your Honors, it's in the notice of intent. Record page 247, one of the things that Dr. Lurie did incorrectly, failure to provide proper COVID protocol, medical treatment, and PPE protocol, guideline implementation. That's in counsel's own words. That's not the expert, that's counsel's own words. As a result of the aforementioned departure from the standard of care, the decedent suffered injuries, which included, and I quote, the exacerbation of COVID symptoms. His words. That's what my client and CL Golden are permitted to rely upon. We then get to the affidavit. And again, this is record page 255. My apologies, 256. There is a breach of the prevailing standard of care with regard to lack of care and proper treatment provided to the decedent after testing positive for COVID. The defendant doesn't decide, or the medical provider doesn't decide what the case is in a medical malpractice claim. That comes from the plaintiff. That comes from the things that they are supposed to do, the pre-suit notice of intent and the affidavit. We then go forward with that. The Bove case, which I was a part of, one of the appellees on that case, we argued that. We argued that we are entitled to look at this document and rely upon it. Case law holds that a party cannot take inconsistent positions. This isn't a case about choosing remedies, Your Honors. This is a case about the plaintiff saying, here's my affidavit, this is a COVID case. Oh wait, there's a statute of limitations? No, it's not.
Well, let me ask you about the affidavit. Is it your position that the affidavit is exclusive to COVID, and so there's no part in the affidavit that would form the basis of a non-COVID related breach?
I think it goes both ways, Your Honor. I think it alleges both, but the fact that it alleges COVID because of the way the statute is written, related to or arising out of, and again, there's plenty of case law that talks about that in the medical malpractice context, arising out of or related to, this affidavit arises out of or relates to COVID-19. Counsel admitted that in his brief. That was admitted at the hearing in the motion to dismiss, that the affidavit actually says that. So according to the statute, arising out of or related to, it's there. And my client's entitled to rely upon it. And that's what the Bove case said. The Bove case said, we are entitled, that is a part of the pleading because you are taking a factual position. This isn't an evidentiary issue. We didn't use this as a basis of evidence. We use this as a basis of fact. What is the case about? Counsel's incorrect in that you can never use the pre-suit affidavit as a basis to dismiss a case. There were two cases that were actually cited in his reply brief. One of them was, the Miles case versus South Miami, where the court looked at the notarization of the expert affidavit to determine whether there was compliance with pre-suit. There was also the Hermoso case, which went through the pre-suit process, the case was filed, and then after there was some discovery, it came to be known that what was said in the pre-suit affidavit wasn't correct, and the court reviewed all of those documents. So for counsel to get up here and say that it never happens, it's just not correct. It happens when there are issues such as this, compliance with pre-suit. And again, compliance with pre-suit absolutely requires that that notice of intent be filed or sent within the statute of limitations. And it wasn't in this case, pursuant to the new COVID statute, the new COVID laws.
Had the notice or affidavit been attached to the complaint as an exhibit, then there would be no question in terms of a motion to dismiss. Would you agree?
Absolutely, exactly. Because under the rules of civil procedure, anything attached is made part and parcel.
But under the Four Corners rule, why shouldn't this case have been decided on its motion for summary judgment as opposed to a motion to dismiss?
Because again, under the Medical Malpractice Act, for a motion to determine, which this essentially was, you can look at the notice of intent and the affidavit.
But you agree that the statute of limitations is an affirmative defense,
Absolutely.
which should be asserted in the answer.
Not in this case, because again, we did that in Bove. That was exactly the issue in Bove, was that what was in the statute, what was in the affidavit, in the notice of intent, which again, wasn't attached to the complaint. The court looked at it and said, you have said when the statute of limitations accrued, when you knew this cause of action began. And we go 2 years from that, and that's the whole basis of the Bove decision, which is, to my knowledge, the only decision which is the most factually similar to this case. So the court can look, the trial court can look at that document. The trial court absolutely can look there and say, this is a COVID case. We now have new statute of limitations to rely upon. You did not comply with that. That was the basis for the motion to dismiss. And that is absolutely permitted in this context. In the normal context, Judge Lewis, I would agree with you. But this is a different context. Medical negligence is different. Again, there's no denying, counsel wants to get up here and say this is not a COVID case. I understand that COVID was in the affidavit and in my notice of intent, but this is not a COVID case. It is a COVID case because they made it a COVID case. At trial, a party can't say, well, I want to talk about the medical records, but I don't want to talk about a little part of the medical record. I don't want to talk about everything. Well, you can't do that.
Well, and that's fair enough, but how far does that go? I mean, is it the case that any patient who had COVID or has COVID, that anything that happens in medical negligence, if they also have COVID when they go to the hospital, that it's going to be a COVID-related case?
That's what the statute says, Your Honor. The statute says arising out of or related to. That's highlighted here. I believe that's 768.38. And again, those
if
terms.
it went that far, wouldn't it have been easy enough for the legislature to say when a patient has COVID while in the hospital, then any medical negligence is covered under the statute? I mean, arising out of and related to has to have some meaning.
It does. There are cases that say it's arising out of or related to in the context of medical malpractice. And again, this was another case that counsel cited. When you have a complaint that may or may not arise out of medical care, you look to what was in the complaint to see if those allegations arise from. Does it pertain to medical care? Arise from, arising out of, related to, those are very broad terms. And there is case law in Florida that says you read it broadly. So the legislature actually did do that via those statutes and using that language.
All right, let's try hypothetical, because I think you're taking this very, very far. So if someone's admitted to the hospital with COVID and they go in for an amputation of their left leg and someone amputates their right leg, that's now a COVID-related claim in your view?
Under the statute, it may be.
It may be?
Maybe.
Why would that, again, arising out of, related to COVID? So the wrong leg amputation, how does that relate to COVID in that type of claim?
Again, Your Honor, those are facts I can't answer. All I can tell you is I'm looking at at what, it's 768.3815.
Yes,
That
and I have it
talks
in
about
front of me just to be
Right.
helpful. Yeah, I guess I think there has to be some limiting principle, but I'm not really hearing it, so.
I don't know under your hypothetical if I can fully answer that question, Your Honor. All I can say is, again, we have to go with the cards that were dealt. And in this case, those are the cards that we were dealt. We were dealt a hand where, and again, this was not the defense. This is not something where we raised it as an affirmative defense because of something we saw in the medical records. This is something that was initially raised because it was stated in the notice of intent very clearly, and it was stated in the affidavit very clearly. Again, what plaintiff's counsel is trying to do is say, I want to put the medical care at issue, but I only want to talk about a little part of the medical care. Well, you can't do that. You can't do that. You say it's the medical care, we're going to look at all of the medical care. You can't just pick and choose what you want to say. I don't want this to be a COVID-related case, even though when I complied with the very thing that gets me into the courthouse, I said it was COVID, but now it's not. You can't do that.
Well, let me go back to something you mentioned earlier to make sure I heard you correctly. I think you referred to the hearing as a motion to determine.
Yes.
What statutory provision were you operating under for that? And I guess the argument you were making is because the trial court was proceeding under that mechanism, it was allowed to consider the affidavit and the notice of intent. Unlike in your traditional notice to dismiss posture, you're not typically allowed to see documents that aren't affixed to the complaint. So going back, so if I understand your argument correctly,
Yes.
what statutory provision were you looking to for that?
It's 766.2061.
Okay.
And it says, at any time, a party can ask the court to determine compliance with pre-suit.
And is that how this was teed up before the trial court as opposed to a motion to dismiss? I'll have to check the record
It was
myself.
not.
It was
I
not.
concede it was not. It was not. But that's what was argued. Because again, you're talking about under 766, and if the court will give me 1 second. 766-1064 is one of the, again, conditions for compliance with pre-suit, and that says that the notice of intent to initiate litigation must be served within the time limits set forth in 9511. I would argue that because this statute changes the statute of limitations, you would also have to comply with now the new COVID statute in the statute of limitations. So Your Honor is correct. It was not titled that, but Judge Lewis asked if this could have been converted into a motion for summary judgment. It very easily could have been converted into a motion to determine. And that's, again, where you see most of the cases where they do, contrary to what counsel has argued here, where you do see the notice of intent and the affidavit reviewed by trial courts to
Was
determine.
that what happened in Beauvais? I don't know if that was part of the written opinion, and you only have to speak to that. What was in the opinion?
Let me see if I can answer that.
Okay, well,
By
if you don't,
state- no, I
you don't need to
can,
go
I
outside the
can.
opinion, but
No, no.
that will help me understand kind of this more relaxed standard for considering extra complaint documents.
In the Beauvais case, and I'm trying to be very careful to stay in the opinion. In the Beauvais case, the court did review the document that was submitted by the plaintiff, and it was multiple defendants who argued that the language in the notice of intent, not the affidavit, but the notice of intent, set forth the date that the cause of action accrued, and the trial court did rely on that document in determining that the case was brought outside the statute of beyond the statute of limitations, so there could be no medical negligence claim. If there are no other questions, I'm going to.
I don't have a copy
Yes,
of
sir.
Beauvais in front of me, but was Beauvais bought as a COVID claim?
Oh, no, Beauvais was 2015, Your Honor, or 2016. So no, there was no COVID issue in that case. Thank you very much, Your Honors.
Thank you, counsel.
Good afternoon, Your Honors. I'll be very, very brief here because, frankly, counsel covered just about everything of importance here. I just want to make it known that there are some differences, as I represent CL Golden LLC, which is a nursing home, and that portions of the claim are not brought under medical malpractice. I'm here under Chapter 400, which you can bring negligence, wrongful death. The issues as it relates to the pre-suit affidavit are still identical. I did want to address what Judge Rowe said with regarding if there was an amputation of the wrong leg. I do agree there does have to be a reasonable cutoff somewhere, although the statute, you could very well argue, does not present that. But again, that's not the case we have here. Their affidavit specifically says exacerbation of his vascular issues, exacerbation of COVID symptoms, gangrenous right foot, and his ultimate death. They are tying it into a reason of his death. You can't separate out those things. This is not similar to something like that where it had absolutely nothing to do with his COVID. They marked the left leg and they amputated the right. That's just not the world we're in. And further to that, people have mentioned 768.38, and the sentence that follows that, related to or arises from, is arguably more important, as it says the term includes any such claim for damages, injury, or death. Any such claim, no matter how denominated, is a COVID-19 related claim for purposes of this section. AKA, it doesn't matter exactly how you want to bring the claim. You don't get to choose. If COVID is a portion of it, it's a portion of it. It's not what you wanted it to be.
Okay, so even assuming, so we take your argument at face value that the affidavit was all about COVID. It was a COVID claim. So the threshold question, I believe, is at a motion to dismiss stage, was the trial court authorized to look at those extra complaint documents in order to dismiss the case? And what I'm hearing today for the first time is this really was more of a motion to determine. This was challenging the sufficiency of the pre-suit process. Do you agree with that position or not, and explain why?
So it's a little bit odd on that, and the basis being, so they had their original complaint. Nothing was ever done with that. It was amended before anyone saw it, I believe. In the first amended complaint, on behalf of CL Golden, and at the time, Mr. Daniels, who I represented both of, Mr. Daniels is now deceased, is not a portion of this case. I was the one who originally brought the COVID arguments. However, I'm under Chapter 400, not malpractice. Well, you don't need an affidavit to proceed under Chapter 400 differently than medical malpractice. So I couldn't make an argument that they didn't meet it under the pre-suit requirement for a motion to determine sufficiency. However, the fact that they intentionally referenced it, and it does appear in every iteration of the complaint, as Judge Rowe said, they didn't just say we comply with conditions precedent. They said we did this affidavit each and every time. So upon looking at it, realizing these things, and it's in, Judge Lewis commented that the statute of limitations is often an affirmative defense, and that's true unless it's bold and obvious from the complaint. And in this case, the complaint and all the documents that go along with it make it bold and obvious. And so we brought
all
in
the
that posture.
documents that go along with it, but was it obvious from the complaint on its face?
The complaint on its face, counsel is correct. It does not have the word COVID in the complaint. It is the incorporated by reference that we've argued. And I would argue that is because they're pleading around their own affidavit. And again, as Judge Rowe said, there has to be a point to the affidavit. You shouldn't be able to get a medical affidavit and then go, oh, which parts don't I like? What shouldn't I include in order to protect my case? That would completely obviate the purpose of having that affidavit to begin with. If you extend this to a logical absurdity, if the medical affidavit didn't even mention the doctor you were suing, if it had the wrong doctor every time it was listed, it would be absurd that a court couldn't look at that and say, this doesn't support this. You're not even close to it. There have to be conditions where you can consider it. Otherwise, why are we doing it? The law doesn't provide for frivolity. You're paying a doctor thousands of dollars to get this document done so that you can get your golden ticket to get into Wonka's factory. Being that's how you get to court.
But that would be brought under a motion to determine sufficiency. Is that correct? If that was, let's use your hypothetical, your extreme hypothetical, how would that be properly challenged by the defendant in that case?
So again, for my portion of it, because the affidavit is not required for Chapter 400, but if they listed, again, a different nursing home every single time, and they don't bring my guy in at all, and then they bring a complaint against me, It would be absurd if I couldn't say they incorporated this affidavit, and then he says right here that I'm not even a part of this case. I mean, there has to be a point where you can consider, otherwise it's a pointless document. And then I just did want to raise also, I don't believe there's been any arguments made that if it is a COVID case that we've exceeded the statute of limitations, but I just want to point out that we did make counter arguments to it, even though it was not brought up in the brief, just an abundance of caution. I don't believe there's any contention that they have not blown the statute of limitations if this is in fact a COVID case. Any other questions, Your Honors?
Thank you, counsel.
Thank you for your time.
Counsel relies on the Bobick case. Can you distinguish the Bobick case?
I can, Your Honor, and I think we do that a number of different ways in the brief. First of all, this obviously doesn't, as I believe you keyed in on, had nothing to do with the COVID-related claim. It had to do with the fact that the party had violated the statute of limitations based upon the allegations in the notice of intent. I think the key thing here is the time where you can consider these pre-suit affidavits, the time when you can consider the information exchanged during pre-suit is in a motion to determine compliance with pre-suit. That's what the case law follows. That's not what happened here. I've been involved in motions to determine compliance with pre-suit. They are full-blown evidentiary hearings. Both, I bring my expert to testify, and oftentimes, the other side has an expert testifying as well. That's not what was done here. This was a motion to dismiss hearing.
But wait just one moment.
Yeah.
I think that if you look at the motions to dismiss, they do allege, failure to comply with the pre-suit requirements, which is something that you would look at with the motion to determine. And I agree, my reading of the record doesn't indicate that it was cast that way. So my question is, could we affirm on Tipsy-Coachman grounds that if treated as a motion to determine, that the trial court correctly looked at the affidavit?
No, for a couple of reasons. First of all, because it's a motion to dismiss, the court can look at whether or not in the four corners of the complaint it appears we've complied based upon the motion to dismiss. It is a separate, entirely different hearing. It's as if you convert it into a summary judgment hearing and didn't give me an opportunity to present evidence. It's just as prejudicial, and it's just for that reason why you can't do that. The court talked about, how do we limit this? The statute doesn't seem to limit. Well, the statute does limit it. There's a definition section, and it then limits what this seemingly broad, and it is somewhat broad, COVID claim by specifically defining and limiting COVID-related claims in 768-381 to 6 specific delineated claims. And there are, underneath those, other things that are not COVID claims. None of the 6 COVID claims listed here, listed in 768.381, have anything to do with the claims we brought in our complaint.
What about what was in the expert affidavit? The opposing side argues that nothing in this expert affidavit would allow for a complaint other than a COVID-related claim.
I don't think he was arguing that because it would be factually incorrect. I think he was arguing that they were all intertwined in the pre-suit. I think he would agree that the affidavit clearly set forth the derogations of the standard of care that we have raised and brought in this case, and it does. So it's completely separate paragraphs delineating the specific negligence we brought. Even again, this is not only something that shouldn't have been considered a motion to dismiss. These are also things that can't be considered outside of the specific hearing of compliance with the pre-suit because statutorily all that stuff's protected, and that's why they're trying to use it now because they know they can't use it later. Finally,
But all of that would be at issue in the motion to determine, right?
that would be at issue in a motion to determine,
Right.
yes, whether or not we complied with the pre-suit. And again, that's not what they challenged here, and that's not what was at issue. But there's
Failure to comply with the pre-suit, wouldn't that be a basis for filing a motion to dismiss for failure to comply with the conditions precedent to filing a lawsuit?
Well, there's a specific statutory section that allows you to provide and thank you for quoting it, because I didn't remember it off the top of my head, that allows you to invoke a special procedure under the medical malpractice statutes. That's a very special, specific kind of hearing that is not a case here, and that's when you would consider those sort of things. And
I'm
that's,
just curious, is that in front of a circuit court?
yes,
Okay.
yes.
I mean, I haven't seen that posture, so that's helpful.
Now,
So you could have been, the defendants could have asked for that.
It could have, and
Right.
when the cases that we're talking about here that are involving these various courts looking at the notices of intent, those were the hearings those were occurring at. Now, again, taking their position, the best case scenario, well, the pre-suit process worked. Let's say we had, a COVID claim, and I'm not disputing that we probably did have a COVID claim. We had a COVID claim and we had a non-COVID claim. We had two claims. The pre-suit process allowed us to wheedle out and not bring the COVID claim. There is, as the court pointed out, it would be ludicrous to state that someone, and in this case, again, we shouldn't be talking the facts here, but here we are. In this case, the negligence related to the failure to treat and examine his lower limbs and his circulatory process far predated any issue with COVID. He incurred damages far before he had COVID. The record shows he got COVID, he recovered from COVID, went back into the same treatment, continued to get negligent treatment regarding his circulation, continued to survive for another extended period of time, and then, and only then, did he pass away. Again, if their position is that all his damages were caused by the COVID treatment, they can raise that at summary judgment. That's not what they've done here. They've completely circumvented the process.
Let's assume for the sake of argument that they had filed a motion for summary judgment with these exhibits. Why should the trial court not have granted the motion?
Well, first and foremost, statutorily, the court couldn't consider the pre-suit affidavit in a summary judgment hearing. There's a lot of case law that we've cited in our briefs and two different statutory sections that are very clear about that. But beyond that, I would have had an opportunity to present evidence myself that would have established that the case that we're bringing is entirely relying upon a completely separate act of medical negligence and has a completely separate set of damages. And ultimately, I think I would have won summary judgment on that, but if I didn't, then there would have been a question of fact that could have gone forward to a jury. But I was not afforded that opportunity because this occurred at a motion to dismiss stage where the court took a myopic view of a affidavit and quite honestly interpreted it completely in their favor and didn't provide me any opportunity to oppose it.
Thank you, counsel.
Thank you, Your Honor.
This concludes our oral arguments for this afternoon. We stand adjourned.